Hello, folks. Welcome back to the Edupedia world. And I am Abhinay Gupta. So, today again we'll be continuing with the winding up of the companies, right? And just remember the provisions of this chapter would be contained in Companies Act 1956 instead of the Companies Act 2013, right? So, we have already had a couple of lectures on this topic. Today, the basic topic under consideration would be the power of the court. And when we talk about the court, there's one thing that should hit your mind, right? Because in just the previous lecture, I guess, we have covered the topic of what the court is, who is the court, and the various situations, the cases that could occur, right? The one tagline, one line that you need to remember when you decide which is the court that will have the jurisdiction over your winding up is that the High Court of the state, right? The state in which you have located your registered office for the maximum period in the previous 6 months, right? So in detail we have done the case study on that. If you don't remember it, or if you haven't been through the lecture, please go back to the previous lecture, because it is very important for you to understand which is the court that has the jurisdiction. When will the district court have the jurisdiction? When will the court of some other state, some other high court have the jurisdiction, right? We have discussed the cases in detail already. Okay, so today we'll talk about the powers of the court. And remember, the powers of the court, when we are discussing in the chapter, will segregate it into two time zones, right? Basically, one is the power before making the winding up order, and the other section is the power after making the winding up order, right? So just winding up order is not the conclusion, right? Is not the last stage of reference to the court. Winding up order is just the beginning. Because after that, when the liquidator is appointed to your company and the liquidator carries on its procedures, right, the court will have an interference at every level, right, until and unless the company is dissolved, right? So if you talk about the powers that the court may have before the winding up order, then they are very limited, right? We have to be counting on the fingertips. It is around 3 powers that we'll be declaring and we'll be discussing right now. But if we talk about the powers after the order of winding up, it goes to a large number, right? But you need not be scared of that. It is a very simple topic that we'll be discussing today. Just pay a little attention in the class and you will know. You'll get the feel, and once you get the feel, you don't need to mug up things, right? So when we go to the power of the court before making the winding up order, so we have 3 powers over there. The first is the power on application for stay of proceedings. So if somebody applies to the court, right, to put a stay on the proceeding of winding up, right, because somebody has made an application, somebody has filed a petition, and the court is still determining whether or not to order winding up. Is it just, is it equitable to order winding up? So before that, while the court is still under this procedure, right, when the petition has been presented and before the order has been passed for winding up, that is where somebody comes up with an application. Please put a stay on the proceeding. That is what the applicant demands, right? So what power does the court have in such situation? So what do you think? What will be the power? The power is, okay, I'll put a stay. If the court has the power to stay, then that is a power. Or it also has the power to restrain the suit or the proceeding, right? So it is basically the discretionary power of the court. The court may, at its own discretion, stay the proceeding or restrain the suit or proceeding against the company, right? But for that, they will have certain terms and conditions that the court will be levying on them, right? Now, first we need to understand who is that applicant, who can be the applicant in this case. So, since the beginning, when we have been discussing about winding up, right, we have been talking basically about the 3 categories of people. One is the creditors, who will be affected by this winding up, right? Because one major ground of winding up is also that the creditors file a winding up petition because they are not being paid their dues, right? So even if the company is going for winding up, the creditors are not sure whether or not they get their money, right? So they are at risk, plus they're losing the business, right? So it is a state of dilemma for them whether or not to take the winding up. So they, at any point of time, if they think that okay, let us do one thing, let us put a stay on the proceeding because now we have some other way out. It can be any other thing. Maybe they are giving more business to the company that will generate cash and that will help the company to pay off the debts, right? Maybe they have entered into a settlement with the company that okay, you pay off, you sell off some of your assets and pay us our debt. If you do that, we'll not advance with the winding up proceeding. So there can be a number of reasons. So the creditors are the one who can apply for putting a stay, because they are the one who can also apply for winding up. So they have been given the power to even put a stay on the winding up, right? The power is also extended to the contributories, the shareholders and the other contributories who are supposed to contribute, right? Either the call money, or if they have any guarantees or some other liabilities to the company, they will have to pay. So even they, if they figure out some other areas or some other solution to this without winding up, because winding up is actually, as we have already discussed, it is the last resort. If nothing can be done, please wind up, because that is when you sell off all the assets and pay off all the liabilities if possible, right? It is not a surety. So the creditors and the contributories have been given the power, and as well as the company. If at any point of time, for example, the creditors have applied for winding up of the company or the shareholders or anything, but now the company suddenly thinks, okay, we have found a way out, we have a supporter, we have an investor, we have a helper. So what do? They apply to the court, please stop the winding up proceeding, please put a halt on it. We have some guests coming in, we have some friends coming in to support, and we have some investments rolling on, so we can sustain. So that can be a reason. So the contributories are also allowed and the company is also allowed. So there are three people who can present the petition, right, before the winding up order is made. That is the company, the creditors and the contributory, right? Now, whom to make the application, right? Because you know there are various courts. Sometimes it is with the high court, sometimes it is with the district court or anything, right? So whom do you approach to make the stay proceedings? Right? Whom do you proceed with the request to stay the suit? So basically, if the court is pending with the high court, if the case is pending with the high court or the Supreme Court, you will have to approach that respective high court or the Supreme Court, because no other court will have a jurisdiction over their power in case of winding up. Right? If it is falling with the high court, you cannot go to the Supreme Court and say, please put a stay on the power of the high court. No. If you want that high court to stay the proceeding, because you know this is a discretionary power of the court, so you will have to apply, you'll have to approach that particular court itself, right? But if it is any other court under consideration, maybe the district court or any other subordinate court, then the application shall be made to the court that has the jurisdiction to the winding up proceedings of the company, whichever court is handling it. It may be the high court, it may be the district court, it may be any court. Right? So if you want to put a halt on the proceeding, you will have to go to that court that has the jurisdiction for winding up. It's as simple as that. Right? Next power that you have is the power to decide the petition. What to do with the petition? They have come up with a petition, right? Petition to wind up the company. You also have somewhere in between, somebody can come and oppose the winding up. They can request the court to put a stay on the winding up. Right? So what are the powers of the court when they are deciding the petition? So basically, it is the general power that it has whenever any other petition also comes to the court. Right? It is no specific power given for the winding up thing. So this provision is basically covered under section 433, right? And the powers basically are categorized into 5 categories. One is, think in a layman's term, what can the court do? Like, I am the creditor, I approach the court, hey, I want XYZ company to be wound up. They are not able to pay my debt. I have given the notice. It's been like over 2 months, right? And the due is over 500 rupees. They are not paying it. It's either due to negligence or their inability, whatever it is. I want that company to be wound up. And the court thinks, for 1000 rupees, right? You come and you ask me to wind up the company. I dismiss it. So the court can dismiss it, right? And it can dismiss it with or without any cost, right? Next, if the court thinks that the company needs to be given some time, or this is not the appropriate time to demand winding up for that company, then it may adjourn the hearing. And that adjournment can be conditional, that okay, on the occurrence of this event, we will take it forward. Or if certain event does not occur, we will just reject it. Right? Whatever it is, it can be conditional, it can be unconditional, that okay, we are adjourning in for straight period of two months without any condition. 2 months hence, we'll again sit down for the case. So one is either it can dismiss it completely or it can adjourn it for the time being, right? Next, it can even make an interim order, and that is whatever it deems fit. Interim order is not the final order. You can, if the court has made an interim order, you can start with some of the proceedings for it, but that is not a conclusion. The court can, when it comes with the final order, that can be a different order altogether, right? And interim orders are generally made when the court thinks that no, it is the necessity to protect the interest of either the contributors or the creditors or the public in general, whatever it is, right? It's an urgent situation, let me give an interim order, and then I will go ahead with deciding as to what to do, right? And when it comes to a conclusion that okay, this is what we finally think that we will proceed with, then it gives the final order, right? Then it's the interim order, and last is give the order for winding up. As simple as that, right? And one is the other orders that it thinks fit. So this is a general rule that has been given, so that if at any point of time we discover something new, the court thinks, let us take this route, the less traveled route. Understand? So there is something unique that has come up, and the court thinks, no, this is what we need to do in this specific case. So we have left the scope open for them, right? The act says any other order as the court deems fit, the court can proceed with, right? So either it can pass an order of winding up, or it can pass an interim order, it can dismiss the petition, or it can adjourn the petition, and the final is an open source for them, right? So that is the power of the court to decide the petition. Last power of the court before making the winding up order would be the power to order winding up. Now basically, if you understand, why do the creditors come to the court to plead for winding up? Why do they file a petition for winding up? Because they know that the company is not paying them their dues, right? So what they want the court to do is sell off the assets of the company, get the money from it, and pay us our due, right? You can go on with the preference level, wherever we stand, I don't care, but even though we don't get the full amount, we are getting something. But in this situation, I think the company is going to pay us zero, right? So that can be a situation. So if they have come to the company and they to the court and they say, please, I want winding up, and the court refers back to the company, and what does the court see? That they don't even have any asset. The company has no asset. What are we going to sell? What are we going to pay? Nothing. So what is the use of winding up? There is a use of winding up. The company needs to be stopped because it has been working in such a drastic situation that it is not even having an asset that can pay off at least some of the debt. Understand the situation? So if the other circumstances, they indicate that okay, the winding up order is justifiable at this point, then just because of a mere fact that the company has no asset will not restrain the court from making such an order, right? Or if they think that no asset will be available after paying off the mortgage, they have loans, they have mortgaged their assets, so maybe they have some asset but they have been mortgaged, and after giving it away they will have nothing left for a winding up. So even in this situation, the court will order winding up if other situations are justifiable, right? So that is all about the power of the court before making winding up order, right? The first thing is the petition comes to the court. What do they do? There are some other people who come to oppose. They bring out an application to stay on the proceeding, and the court can order the stay. If there is no stay order and the court moves on and it is deciding the winding up, right, then it has again 4 powers: either adjourn it or dismiss it, pass an interim order, or pass a winding up order, and one open source definitely. The last is they will order winding up if they consider it to be justifiable. Not having any asset or not having any asset after giving out the mortgage is no cause for restricting it, right? That is all about the power of the court before making the winding up order. Okay, now we move on to the next part, which is the power of the court after making the winding up order. Now the procedures we have seen, what has happened before the order has been made. Now consider that the court has given a winding up order. Okay, this is an order of winding up. Please, liquidator, go start the winding up procedures for the company, because that is a continuous process, and at the end the company will be dissolved, right? So let us see. We have a number of powers given to the court, and we'll be discussing each one of them in detail now. right? So the number one power that we'll be discussing is the power to stay winding up. So we have already seen in the powers before the winding up order is made that the winding up order can be stayed, right? People can file, the contributories, the creditors and the company can file an application to stay on the proceeding. And the same thing is applicable even after the order has been passed, because winding up is not a joke, right? And on the face of it, the court will not want a company to be wound up. We have discussed in detail what are the consequences of winding up the company, right? If you go back to the previous lectures, we have discussed that will hamper the economy, that will hamper the market, that will hamper the employees, that will hamper a lot of things over there. So the court on the first hand, they will not want a winding up proceeding to happen, right? So they have given all the spaces open. If anybody can come and put a stay on the winding up, we are ready to do it. Please be justifiable. That's it, right? So they are giving out scope. If you can avoid winding up, please do it. Whosoever you are the creditor, you are the contributory, you are the liquidator, whosoever can help the company out of the winding up, they are most welcomed. So it is the power of the court to stay the proceeding, right? So when can that application be made for staying the winding up? That can be made at any time after making the winding up order. The liquidator is proceeding with its task, no problem with that. But one fine day, if somebody comes up, please, I want to stay on the proceeding, and this is the reason for that. And if it is justified, the court will put a stay, no matter at what stage the winding up proceeding is, right? And who are these people who can make the application? As we have seen earlier, the most important people over here are the contributors and the creditors, CC, right? And before the winding up order, we have seen that even the company can come to stay the proceeding. But now the company has no power. The directors, they have no power in their hand. Why? They have been replaced by the official liquidator. The court has appointed an official liquidator to the company, and they are managing the affairs of the company. They will be selling off all the assets. All the assets, properties will be vested upon the liquidator, and they will deal with it, right? That is something you know already. So now the power will also be given to the official liquidator. If you want to stay the winding up, please come to me, make an application, I'll stay the winding up, right? But one thing is for sure, that if you want to put a stay order, you will have to put a stay order on the entire proceeding of winding up. You cannot just say no, this process, the liquidator is falling, I don't want it, right? There are some issues with that, so please, I want you to stay that proceeding for some time. No, that is not possible. If you want the winding up to be stayed, I can stay the entire winding up. Otherwise, I don't want you to hinder into the work or the job of the official liquidator. That is very simple. If you have a justified reason, right, so big enough, so huge that it can save the company from the winding up, then you are most welcome for that, right? Now, even the court needs to be satisfied, right? Because if it has already given the winding up order, that means the court is in favor of winding up. The court has already seen a lot of things. They have been through a lot of documents. They have been through a lot of cross checks and references, right? And then the court has come to a conclusion that okay, we'll order winding up. So putting a stay on the winding up is not that easy. But if it is proved that no boss, if you stop the winding up, that will be beneficial, the court is very happy to do that, right? Understand, because that is not the intention. The court does not voluntarily want a company to be wound up, right? So how does the court be satisfied? For that purpose, the court will require the official liquidator that is appointed by the court to furnish a report, right? And that report will contain all the facts or the matters which are in the option relevant for the application. Like for example, if the creditors have come with an application that to the court, right, to put a stay on the winding up, then whatever grounds they are bringing forward, if they are filing an application, they have certain grounds, they have certain logic, certain facts based on which they are making the application. So that fact, that ground for putting a stay on the winding up proceeding will be checked, cross-checked in the report by the liquidator. So the court will demand the liquidator to bring forward a report. If the creditor is saying something like this is happening, please bring a report, let me see what has happened. And if the liquidator brings out a good report and the court is satisfied, the court will throw out a stay on the winding up. So are you clear with that? Now we move on to the next power. So what is the next power? It is to settle the list of contributories. Now, when you start the winding up proceedings, right, the list of contributory is one of the most important thing, because as you know, the companies are performing well. So there is a high probability that the company does not have sufficient asset or money to pay off the debts and liabilities. So what do? You have to pay them off. So now you call the people who are the contributories for the company. Please contribute into the fund of the company. We need to pay off the creditors. We need to pay off the liability that you people have taken up. So the first thing what the court will call is, listen boss, if there are people who have their call money pending with the company, right, they have not paid the entire call money for the shares they have taken, so please now come and settle up all the call money. Give me all the call money. I will want to utilize it first. Right? So that is why it is important that after you have given out the winding up order, you will have to settle the list of contributories. Who are the people who will be contributing? Right? If you need some asset, if you need some money, whom do you approach? Who are the people who will be bringing in funds to pay off the debt? Right? And while you are preparing the list of contributories, you need to segregate it into two sections. One is the original contributories. Right? By original contributory, I mean the contributory in their own rights. And one is the duplicate contributory. Please do not use the word original duplicate. It is just for you to understand. Right? And who are the duplicate contributories? They are the contributories who are being representative, right, or who are liable for the other's debt, someone else's debt. They are the contributories who are representatives. So they're not contributories by themselves. They don't owe anything to the company, but on behalf of someone else, they have the liability to bring out either the call money or whatever the other person owed to the company. Right? And if the court feels that yeah, it is necessary to make the call, the court will make the call. Right? But if it sometimes feels that okay, no, making the call is not necessary because we have sufficient number of assets, and if we sell off those assets and we are getting the fair value in the market, then we will very well be able to pay off the debt. So in that case, they will not make the calls, because that is not required. Why? Because once they make the call, you know what happens is the contributories, they come, they contribute, the fund goes up and they pay off everything. Now if there is something surplus remaining, they again have to distribute it back to the contributories. Right? So on the first case, if they don't think that it is needed and they have surplus to pay it off, then pay it off. Whatever surplus now you will have, you will again send back to the contributories. Now what is the point of again bringing the money from them and again giving it back to them? It is a cumbersome process. Right? So they are playing very safe. If they don't want the extra fund, they will dispense with the settlement of the list of contributories. Right? Now the court also has the power to rectify the register of members. So if there are certain members whose names are not entered, right, the court has the power to modify it. They'll enter the name of those contributories. There are certain contributories whose liabilities have been like knocked off. Like if they are supposed to make some contributions, the register has been amended, and so they now the register shows a phase that no, nothing is due from this person. But the court has the power to amend it. No, if everybody is bringing in this amount, he is supposed to bring in this amount. Amend the register. Right? And the last thing is that the court shall cause the asset of the company to be collected and applied in discharge of the liability. Right? The liquidator is already there. The liquidator will take away all the assets of the company, will try to realize them into the market, and whatever proceedings they get from the market, they will utilize it to pay off the liabilities and the debts of the company. Right? So that is how they settle up the list of the contributories. Right? And that is also about the application of the asset. The next power that we have is to transfer the property to the liquidator. The liquidator takes away everything, as I have already told you. Right? So the court will require that when the liquidator has been appointed to the company, right, then all the contributories, the trustees of the company, the receivers who have been appointed for that company, or any banker of the company, agent, officer, employee, whosoever is connected to the company, right, they will have to pay, or they will have to deliver, or they will have to surrender or transfer whatever source it is, right, to the liquidator if they have any money. So if they have any money that is pending, that is due to the company, they will have to pay it to the liquidator. If they have any property of the company with them, they'll have to surrender it to the liquidator. If they have any books with them, they'll have to transfer it to the liquidator. Right? If they have any documents, any books, they'll have to transfer all of them to the liquidator. They'll have to surrender it completely. Right? So what you understand is, if I talk about the list, it is the contributories, the trustees, receivers, bankers, agent, officers and employees. They will all give away everything they have taken from the company. Please give it back. We want to realize those assets and get some money to pay off the debt. Right? That is one liner that you need to remember. Everybody bring back everything. That is it. Right? Next power that we have is the payment of debts that is due by the contributory. So when we talk about the payment of debt due to contributory, what do we mean? So first thing, as we have seen, is whenever the company, the court will prepare the list of the contributories. Like that is the first procedure that they'll follow. After that, what happens is, now they will see how many contributors have some money for the call to make. So that is the first priority, make all the calls. Right? So the call was made, the call money was brought into the company, and then they checked how much surplus fund now we have. Like they think that the funds are enough to pay all the liability and they have some surplus remaining, they'll pay it back to the contributors, right, in the proportion in which they bought it. But if they don't have anything and now they require more, so what is the next step? Now the next step is that the court will see which are the contributories who have some debt due to the company. If you have it, bring it. This is the time. This is the time the company needs that money. They need to pay off the liability. Right? So now the contributories will have to pay the debt that is due to the company. Got the point? So the four powers that we have seen is the power to stay the winding up, because that is what the court have always wanted. Anybody come up, the liquidator, contributory or the creditor, please file an application and we are very happy to help you. We are happy to stay the winding up. Right? Second is, now if the winding up did not stay and the winding up is continuing, the first primary thing that they'll do is prepare the list of contributories. Right? People who will give the money. Segregate it, original and the representative. Right? And then transfer the property to the liquidator. Everything. Any person have been connected to the company, they have taken anything from the company, maybe books, papers, properties, money, whatever you have, bring it back to the company. The company needs it. It's the company's property, bring it back. Right? After that also, if you need surplus fund, you will call for the debts that is due to the company by the contributories. Understand? So these are the four powers that we have covered, and we still have 8 powers to go. Right? But since we have a shortage of time in the lecture, we'll take it up in the subsequent lecture. Right? So until then, you'll have to stay tuned. And this is Abhinay Gupta, and he will be back. Right? So I'll be signing off for the lecture today. Thank you very much.